How's it going, everybody? Welcome to 2A News Now. If you're new to the channel, my name is Troy, and here at 2A News Now, you get your Second Amendment news straightforward and to the point. On Friday, the Trump administration did something that some say is historic, and it's also the first time the Department of Justice has done something like this. And the Department of Justice was formed in 1870 by Ulysses S. Grant. So what did the Department of Justice do? On Friday, they filed what you call an amicus brief in the Seventh Circuit Court of Appeals. And if you don't know what an amicus brief is, I'll tell you a little bit about it. It's a legal document filed by a non-party in a lawsuit, and it provides the court with additional information, perspective, or arguments that are relevant to the case. The briefs are submitted by individuals or organizations who are not directly involved in the case, but have a strong interest in the outcome or the legal issues involved. So like I said earlier, the Department of Justice was formed in 1870, and this truly is historic, and it's the first time that the Department of Justice has ever filed an amicus brief opposing a ban on assault weapons. And this brief by the Department of Justice is about 15 pages long. But in short, they came up with 3 good reasons why the court should reverse its decision. Also in the Department of Justice's brief, they say that the Seventh Circuit Court just simply got it all wrong in a case called Bevis versus Naperville. And that case is an assault weapons ban. And in that case, the court ruled AR-15s and other semi-automatic long guns are militaristic firearms, and they are not protected by the Second Amendment. So here's the first reason that the Department of Justice gave, that the Seventh Circuit Court of Appeals got it all wrong. The position fails as a matter of text, history, and precedent. The Second Amendment's prefatory clause, a well-regulated militia being necessary to the security of a free state, certainly does not limit the scope of its operative clause. As the Supreme Court made clear in Heller, but the Supreme Court was just as clear that the prefatory clause's text nevertheless announces one of the Second Amendment's purposes, and logic demands that there be a link between the stated purpose and the command. The Second Amendment's militia-related text, as interpreted by the Supreme Court, thus suggests that the government may not prohibit weapons simply because it considers them militaristic. The contrary claim that militaristic weapons fall outside its scope wrongfully requires reading the prefatory clause entirely out of the Second Amendment. And there was even a case back in the 1930s called the Miller case. And in that case, it was ruled that only those arms best suited to a militia are protected under the Second Amendment. But it just seems that the Seventh Circuit Court and other courts just basically ignored that, so they can uphold bans on AR-15s and other semi-automatic firearms. Now here's the second argument that the Department of Justice said in their brief. Multiple Supreme Court justices, including Bruin's author, have since made it clear that they disagree with Bevis and other recent lower court opinions, and that the court is likely to grant certiorari in the next term or two to address the errors in those opinions. Third, after the court's decision in Bevis, the district court held a multi-day bench trial, heard significant evidence regarding the issues in the case, and made factual findings that show that the act violates the Second Amendment as applied to semi-automatic firearms and attachments that are common use by law-abiding citizens for lawful reasons. Also, the Department of Justice pointed out that when the Supreme Court ruled in Heller that arms cannot be banned unless they're both dangerous and unusual, the AR-15 and other arms banned by the Protect Illinois Communities Act aren't uniquely dangerous, and they're certainly not unusual, given that we're talking about the most popular rifle in the country. The Department of Justice third reason that they gave in their brief is kind of long, so I'm just going to cherry pick some of the good parts out of it. But I'm going to pop it up on the screen so you can read the whole thing if you would like. After conducting a multi-day bench trial, the district court found that AR-15s and certain other firearms banned by the act are in common use by the law-abiding citizens for lawful purposes, including self-defense. Among other specific factual findings, the court found that uses of AR-15s for unlawful purposes such as mass shootings, albeit reprehensible and tragic when they occur, are clearly outliers and are exceptions, not the rule. AR-15s also are not dangerous, at least as the term is used in Second Amendment case law. Of course, all firearms are dangerous in some sense, but to be dangerous in the relevant sense, a firearm must be especially dangerous or uniquely dangerous. AR-15s are not especially or uniquely dangerous as compared to other firearms, semi-automatic handguns that are in common use. AR-15s are semi-automatic, but so too are most handguns. Quoting Justice Kavanaugh in the statement on Snopes, criminals use both AR-15s and handguns in unlawful ways that threaten public safety, but handguns can be more easily carried and concealed than rifles. And handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. In some, there's no meaningful distinction between semi-automatic handguns and semi-automatic rifles, and it would thus strain logic and common sense to conclude that the Second Amendment protects semi-automatic handguns but does not protect semi-automatic rifles. And what Judge Kavanaugh said is exactly right. And as I mentioned a couple of times earlier, this is historic, and it's the first time that the Department of Justice has sent a brief to a court saying that a semi-automatic ban and a magazine ban that is in Illinois is unconstitutional. And even after the Department of Justice sent this brief to the Seventh Circuit Court, and the court decides to keep the ban in place, when the Supreme Court of the United States finally takes up this case, the Department of Justice's brief that they sent to the Seventh Circuit Court should help the Supreme Court of the United States vote in the right way and vote the Illinois' ban on semi-automatic firearms and high-capacity magazines is unconstitutional. I would really like to hear your thoughts in the comment section down below. What you think about this brief that the Department of Justice has sent to the Seventh Circuit Court. Also, I appreciate everybody that supports the channel. After every video that I post, you guys are always crushing it by liking, sharing, and subscribing, and hitting those post notifications, as well as leaving comments in the comment section. And I really do appreciate it, and it helps the channel out, and it helps it to continue to grow. And I invite all of you to come back and watch my next video.